Thomas Massie walked into that hearing room carrying a red folder so thick the security guard scanned it twice. Massie just smiled and said 5 words. Evidence does not need clearance. What came next was not a congressional hearing, it was an ambush, and Pam Bondi never saw it coming. The first 40 minutes were standard procedure. Budget allocations, civil rights enforcement, prosecutorial discretion. Bondi handled all of it with practiced ease. She gave her usual non-answers, checked her phone twice. She looked almost bored. Then Massie took the microphone, and the room shifted. That electrical charge when everyone suddenly realizes something is about to happen. Madam Attorney General, I want to talk about a wire transfer that occurred on February 8th of this year. Bondi's expression didn't change. She had heard this before. Anonymous sources, leaked documents, conspiracy theories. She had her standard response ready. Congressman, I am not aware of any specific transfer. Massie's hand came up. Not aggressive, just a calm, deliberate gesture. I am not asking if you are aware. I am telling you what I found. He opened the red folder. This folder contains bank records, wire transfer receipts, and internal DOJ memos documenting a payment of $847,000 that moved through the Justice Department on February 8th, 2 days after you were confirmed as Attorney General, transferred to an offshore account registered under a shell company in the Cayman Islands. The room went silent, not the polite quiet of people waiting for the next sentence, the heavy, thick silence of people who just heard something they cannot unhear. Document 1, Wire Transfer Authorization Form. Origin, Department of Justice, Financial Management Division. Destination, account ending in 7473, registered to Executive Branch Consulting Services. Authorized by your Deputy Assistant Attorney General, Richard Feldman. Notation at the bottom, legal settlement, executive privilege claim, classified matter. He set it down. Do you know what settlement this refers to? Bondi leaned forward. Congressman, I categorically reject any characterization of improper financial activity within the Department of Justice. You can reject it all you want, Massie said. It won't change what is written on this document. Document 2. 3 days after the wire transfer, a DOJ internal memo went out to all division heads. Subject, Executive Branch Protection Protocols. Effective immediately, all documents related to Settlement Agreement EP0225 are designated attorney-client privileged and exempt from FOIA requests. Massie paused. Attorney-client privilege. That is interesting, because attorney-client privilege protects communications between a lawyer and their client. So who exactly is the client here? Is it the Department of Justice, or is it someone else? A murmur went through the room. Journalists were typing. Committee members were exchanging looks. Bondi's jaw tightened. Just barely, but it tightened. Document 3. 6 days after the original transfer, a Treasury Department analyst sent an internal email to their supervisor flagging the transaction as unusual and potentially requiring a suspicious activity report, a legal requirement under federal banking law. The analyst's finding: the receiving entity had no employees, no physical address, no business history. The supervisor's response: do not file. Matter is classified. Executive branch decision. Massie looked at Bondi. Someone at the very top of the United States government decided that $847,000 moving to a shell company was not worth investigating. Who made that decision? Bondi's lawyer leaned over and whispered urgently. Bondi shook her head slightly. She was going to handle this herself. Congressman, decisions about settlement payments involve complex legal considerations. Massie's hand came up again. I'm going to stop you right there. Complex legal considerations. Let me show you how complex it got. Because what came next made the $847,000 look like the first sentence of a much longer story. Document 4. obtained through a federal court order the week before the hearing. The complete transaction history of the account that received the initial transfer. From February 8th to February 23rd, 15 days, that account received 3 separate deposits: $847,000 from the Department of Justice, $293,000 from an entity called the National Security Litigation Fund, $1.2 million from something called the Presidential Legal Defense Trust. Total, $2.3 million. And then on February 24th, every single dollar was transferred out. 3 accounts, one in Switzerland, one in Singapore, one in the British Virgin Islands. All 3 registered to trustees whose identities are shielded by foreign banking secrecy laws. Massie set the page down slowly, and at the bottom of this final transfer authorization is a notation. He paused. Payment in full for settlement of claims related to J Matter. J Matter, Jeffrey Epstein. The room exploded, not metaphorically, literally. Shouting from the gallery, journalists jumping to their feet, camera operators scrambling for better angles. The committee chairman banging his gavel so hard it echoed, "Order! Order in this chamber!" Bondi sat frozen. Her face had gone pale. Not white, pale. Like someone who had just been shown something she was not supposed to see from this side of the table. Her lead lawyer stood up so fast his chair scraped the floor. "Mr. Chairman, I must object to this line of—" "Sit down, counselor." Massie's voice was ice. "Your client can answer for herself." But Bondi didn't answer. She stared at the bank routing numbers projected on the screen behind Massie's head. 10 feet tall. Every digit visible to every camera in the room. Massie said quietly, "Madam Attorney General, do you recognize this transaction?" Silence. "Do you know who received $2.3 million in exchange for settling Jeffrey Epstein-related claims?" Bondi's lawyer tried again. "Congressman, my client needs time to review." "Time." Massie stood up. "I have never seen a Republican congressman stand up during a hearing to question a Republican attorney general like this." "Time. This transaction shut down an active investigation. It paid off witnesses. It buried evidence." He pointed at Bondi. "And you authorized it 3 days into your job. 3 days. What did they tell you in your first briefing? What did they ask you to do?" Bondi finally spoke, her voice quiet and strained. "Congressman, I was not personally involved in every financial transaction that occurs within a massive federal agency." "Don't," Massie cut her off. "Don't tell me you weren't involved. Your deputy signed the authorization. Your office classified the documents. Your press team issued the cover story." He picked up another page. "And here is what happened after that payment cleared. DOJ activity on Epstein-related litigation dropped 94%. Witness depositions, 0. Document production requests, 0. Active case files, 0. You didn't just settle one claim, Madam Attorney General. You killed every single investigation your department had into Jeffrey Epstein's associates." But the most alarming document was still in the folder. Document 5, a Department of Justice internal list. Created in 2023 and updated in 2025, during Bondi's own tenure. Title: Individuals excluded from Epstein-related investigative activities. He held it up. 47 names. Each one assigned a code explaining why they are protected. Code A, political sensitivity, 12 names. Code B, diplomatic relations, 8 names. Code C, national security concerns, 15 names. And Code D, he paused, executive branch protection, 12 names. The room was dead silent. You could hear people breathing. "Executive branch protection," Massie repeated. "The White House is protecting 12 people connected to Jeffrey Epstein from Department of Justice investigation." He looked at Bondi. "Is that national security, Madam Attorney General, or is that a cover-up?" Bondi's lawyers were in full panic, looking at each other, writing notes, whispering, but they had nothing. The documents were there, the evidence was there, and in 15 minutes, Massie had laid out the entire money trail from start to finish. Then he said his final words. "Madam Attorney General, I came here today hoping you would explain this, hoping you would tell us there is some reasonable explanation for $847,000 moving to a shell company 2 days after you took office. But instead you have sat there in silence." He looked at his watch. 60 seconds of silence. I timed it. 60 seconds where you could have denied this, could have explained this, could have defended yourself. But you didn't. He gathered his documents. These bank records will be entered into the congressional record today. Every transaction, every routing number, every shell company. The American people will see it with their own eyes. And those 47 names, those names will come out. Maybe not today, maybe not tomorrow, but they will come out because the truth always comes out, and this cover-up cannot remain hidden forever. He stepped back from the microphone. "My time has expired, Mr. Chairman." What Massie brought to that room wasn't accusation. It was architecture. Document by document, he built a structure that Bondi could not dismantle because she had no tools to dismantle it with. The wire transfer existed. The shell company existed. The classification memo existed. The Treasury flag existed. The $2.3 million existed. The offshore accounts existed. The notation saying J. Matter, Jeffrey Epstein, existed. And the list of 47 names existed, updated during her own tenure, with 12 of them marked for executive branch protection. Bondi's defense, "I was not personally involved in every financial transaction," collapsed the moment Massie showed that her deputy had signed the authorization, her office had classified the documents, and her department had shut down 94% of its Epstein-related activity in the weeks that followed. You don't need to sign every document to be responsible for what your department does. The Attorney General is not a bystander in her own building. The Epstein case has always operated on the assumption that the public would eventually lose interest. That classification, legal jargon, and sealed records would wear down the appetite for answers. That worked through multiple administrations. It stopped working the moment Massie walked in with a red folder and a federal court order. Because documentation is different from accusation. Accusations can be dismissed as partisan or speculative. Documents cannot. A wire transfer receipt does not have a political affiliation. A notation that says Jeffrey Epstein's name at the bottom of a $2.3 million transfer does not care who is in the White House. That is what made those 60 seconds so devastating. Bondi is a former prosecutor and a former state attorney general. She knows how to answer a hostile question. She knows how to pivot. She did none of it. Because the documents didn't leave her anywhere to go. The congressional record now contains every document Massie read aloud, every routing number, every shell company, the notation that says J. Matter, the 47 names and their protection codes. None of it can be reclassified. None of it can be sealed. It exists permanently in the public record. And those 47 names, the ones marked Code D, Executive Branch Protection, are still shielded today. But shielded is different from hidden. The public now knows the shield exists. The public now knows there is a list. And 60 seconds of silence from the Attorney General of the United States is not a denial. It is not a defense. It is a confirmation that the question was worth asking, and that the answer is something she cannot say out loud.